Good morning, everyone. I'm delighted to welcome you all to today's webinar on real estate Q&A. Get your legal and market doubts cleared. We have the honor of introducing our speaker, Advocate Lalitha Sridhar. Lalita Sridhar is a partner at LR Advocates with over a decade of experience in real estate, family, and consumer law. She has advised leading developers, builders, and realtors on property due diligence, contracts, and registrations, and is well regarded for combining legal precision with practical solutions. I would also like to introduce our esteemed facilitator for today's session, Mr. Manoj Agarwal, our Managing Director. Under his leadership, Agarwal Estates has become a trusted name in the real estate industry, recognized for its professionalism and client first approach. Today's session will run for approximately 45 minutes. You are welcome to ask questions at any time during the session by unmuting yourself or by typing them into the chat box. So, without any further ado, let's get started.
Thank you so much, Aishi and Manoj sir, for giving this opportunity to present before all of you. So, right now for this webinar, we are just discussing on basically the important aspects that all the realtors should know. And Before I start the webinar, the thing that I want to tell you guys is a brief introduction of what LR Advocates is. So it's a family-run law firm with 50 plus years of experience, and we have founded LR Advocates in 2021 with me and my husband partner Rohit Achar being the partners of the firm. We have core expertise in litigation, real estate due diligence, banking, contracts, consumer and family law. So we serve individuals, startups, developers, corporates, financial institutions, and people who are interested. We also teach people who are interested to know law. Now, we're coming to the very important aspect as to why legal due diligence matters. So usually people come to us asking, why do we have to do due diligence? How important it is? Absolutely important, because one, we have uh, we have to prevent the clients, whether it is you or whether it is us as advocates, have to prevent clients from any fraud or any sort of litigation issues. We have to make sure that the ownership is clear and the approvals that are there for the property is clearly given to them. And also, in case there is any sort of issues with respect to loans, resale and registration, if the due diligence is not clear, it becomes very difficult for them to process this. And to basically, very importantly, financial investments, because they would have been putting their financial investments into a property, and if they take anything which is litigation property, it is going to become a loss to them. And for you guys, very important is to build the trust and credibility. So as a realtor, building the trust and credibility is what is important. And I think for all these reasons, due diligence of particular property is very, very important. Now, usually people have this question as to what are the essential documents that are required for an apartment. Does it vary from the plot? Absolutely, yes. For an apartment, you need certain basic, property papers that an advocate usually asks. And for a villa plot or a plot that a person is purchasing, there are different set of documents you have to ask. So if you come to an advocate saying, look, I'm purchasing an apartment, what are the different documents that is required? We ask for title deeds, minimum of 30 years. Why 30 years? Because Limitation Act says 30 years is the time where a government can file a case against you. So that becomes important. That's why 30 years chain of ownership is asked. So we ask title deeds for 30 years. We ask for the current owner's sale deed. We ask for any joint development agreement or a GPA. And EC is also, encumbrance certificate is also asked for 30 years. We ask for E-Khata. We also ask for building approved building plan and commencement certificate. And if the project is completed, we ask for completion certificate or occupancy certificate. And very importantly, we also check NOCs. There are multiple NOCs that different departments give, whether it is fire, water, pollution control board, society, association, multiple sort of NOCs that comes into play. So we check all the NOCs, and property tax receipt is very, very important that we check. And RERA registration is something that we also check, so that we tell the client, look, if RERA is there, then it is always a safer bet. So these are some of the documents that we usually tend to ask for apartment. Okay, and if you say what about the land or sites, in that case, also we ask for 30 years of property papers, sale deed of the current owner. We also see encumbrance certificate. Here we see RTCs or MRs. So RTCs also we usually ask for 30 years. MR for whatever transaction has happened during that term, we ask for MRs for that mutation register extract. We also ask for khata, or we also ask for conversion order, which is very, very important for layouts. So conversion order from agriculture to residential or non-residential, that conversion order is very important. We also ask for layout approval, because without proper layout approval, then the khata becomes an issue. And we also ask for NOCs. This usually most of them skip. See, if for layouts, we need to ask NOCs from the electricity department if it is coming under BBMP ambit, or you'll have to ask a letter from the panchayat asking whether there is water, electricity, and sewage, the facilities that are provided for the layout. And then you also have to ask for property tax receipts. Anything, irrespective of whether it is a plot or an apartment, tax paid receipt is very, very important. And if it's a layout, then you also ask for RERA registration. So these are some of the key documents you need to ask for an apartment. Also, this is some of the key important documents that you ask for the plot as well, right? Now, before we step into E-Khata and B-Khata, this has always been a challenge or an issue with the clients. Most of the realtors face this because they always come and say we or rather promote E-Khata properties, and not go into B-Khata properties. I am sure most of you are already aware of what E-Khata and B-Khata is. So just to give you a brief idea what E-Khata is. E-Khata is something which is officially the property account. Basically, khata is a property account that is kept with BBMP or BDA, which says that it is complied with all the legalities and the tax is paid, and it is eligible for loans, approvals, and resales, and basically it is safest for all the transactions. But when you go to B Khata, it clearly says that it is only for tax collection purpose. It is not a legal ownership, if you see. And obviously, B Khata is linked with any sort of violations, missing approvals. There can be no loans or no approvals can be given. It is a poor resale value, like most of you know. And Supreme Court itself has declared it illegal in 2014, one of the judgments, right? So these are the issues with A Khata and B Khata property. Nonetheless, we have recent updates on the Khata system in Karnataka, like most of you are aware of it, that we have Greater Bangalore Governance Act that is coming into place, and where we instead of BBMP we have Greater Bangalore. So where they in that act they are trying to bring in regularizing B Khata into A Khata. Now, what they have clearly said there is any property which is constructed before 30th September 2024 is eligible for regularizing from B Khata to A Khata. Nonetheless, the BBMP will do the survey. The BBMP will come and see whether you are, compliant with the zones. It is going to check whether you're compliant with the revised master plan. So all these checks will be done, and only then the regularization will happen. And also they are going to check how much of deviation you have done, and they are going to they are going to regularize from B to A khata after paying sort of fines and penalties and all these things. So this is what they have come up with, and they're very, very clear that this is only going to apply for the apartments or houses that are constructed before 30th September 2024. This does not apply to vacant plots. So there are misconceptions that B Khata plots will also be regularized and made into A Khata, but until now there has been no notification on that regard. Whatever notification has come, it is very clear saying that the plots are excluded in this, and only constructed apartment or houses are part of this. And very clearly the law says that no new B Khata is going to be given post September 30th, 2024. This is when we got, from October 1st, we got E-Khata concept. So October 1st, 2024, the concept of E-Khata started in Bangalore, which was already there in most of the parts of Karnataka already by then. It was made mandatory from October 1st, 2024. And since July 1st, 2025, all BBMP properties must be migrated, and without the EPID or E-Khata number, no building plan approvals are happening online. And one-time settlement option is given by the government to make sure that they convert B Khata into A Khata. It is a OTS system that they are planning to do it. Until now, they have not come up with a concrete plan as to what is the amount that they'll be taking, what is the percentage of it, what deviation will be allowed, what will not be allowed. Nothing of concrete of that sort has they have come up with. But all they have told us, they are going to give a one-time settlement option, and it is going to be across Karnataka, not just Bangalore, but across Karnataka. So these are some of the recent updates on Khata in Karnataka. Now, people also have issues with tenanted properties. So you go as a tenant, and you realize that someone else has taken over the property, and your owner is no more the owner, and someone else has replaced to them. Then what happens to you? So this always is a big question or a challenge to the realtors, because you would have introduced the tenants as to someone as owner, and suddenly that owner sells the property and there's a new owner. Then what happens to this whole rental agreement that is done? In that case, law is very clear. It says that lease remains valid even after the property is sold. So even if I am the owner, I'm selling the property, so the new person will act as a owner of the property, and the rental is going to continue unless until they mutually agree, and then they say no, the tenant has to leave and go. It's a different story, but tenants' rights continue till the lease expiry. So this is very important for your understanding. Let's say, take one example, flat leased till December 2026. For example, if a flat is leased till December 2026, imagine it is sold in 2025. So the new purchaser or the new buyer becomes the landlord, but the tenant stays till 2026. So until whenever the rental agreement is, till then the tenant becomes the tenants can stay in the property, and the new owner will assume as the landlord of the property. Okay, no immediate eviction can be done, and unless until there is consent or there is actual legal grounds for eviction, then in that case only eviction can be done. Now, there's always this question as, what if tenants overstay? What will happen if tenants overstay? Obviously, if a tenant is overstaying, then you give them a notice saying that, look, you are supposed to live by this October 2025, but you are supposed to leave in June 2025. It's already been October 2025. You're still not left. So you give them a heads up saying that, look, you need to quit the premises. Otherwise, I'll take legal action against you. You can't forcefully push that person out. You can't cut the water supply. You can't cut the electricity. Supreme Court has been very, very clear on that. No cutting of electricity, no cutting of water supply. If a tenant is staying for a longer term, that is not a solution. You take help from the police. You ask the police, you go tell the police, look, this person has done this. Obviously, this is a matter which does not come under the ambit of criminal law. Nonetheless, police is going to help you with respect to vacating the tenant. But what is the main course of action that you can take is, you are going to send a legal notice to the person asking them to vacate. If they don't vacate, then you have to file a case against him in the court. and then you have to run the case and make sure that the case is in favor of you and vacate the person with taking all the profits that he has made or taking all the rents from him, whatever is due that he has to pay you, right? So this is something that happens where if tenants overstay. Now, when you come to rental agreement registration, this has always been a question that should we register rental agreement? The answer is, if it's less than 11 months, you don't have to register as per the law. E-stamp paper would work, okay? Obviously, it is a faster and cheaper option and legally valid, but obviously, it is weaker when it comes to legal disputes. Because obviously registered document will always have a upper hand compared to the unregistered or e-stamp agreement. But nonetheless, usually to save the amount, people would want to go for e-stamp paper. That you can do within 11 months. If the tenure of the tenancy is for within 11 months, you can go for e-stamp paper. But if the tenure is for more than 11 months, if it is 1 year, then 0.5% is the rent, on the stamp duty and registration fee. And if it is 1 to 10 years, it is 1%, and 10 to 20 years it is 2%, and 20 plus years it is 3%. So they have made certain changes to this, and you will have to register if there is an issue with respect to whenever there is an issue with the e-stamp paper and a registered rental agreement. Registered rental agreement is going to always stand up because it is a registered document. Now, always the question happens, what happens if I'm selling a property which has a loan? So it is more common that all of us are going to take loans whenever, we are purchasing new property. I'm sure our realtors must have come across a lot of them saying we want to go for loans for purchasing any property. So in that case, if I want to sell the same property, can I sell it with loan? Yes, you can sell it with loan. Say, for example, I've taken a loan and there is still about 20 lakhs pending in the loan. Can I sell it to some person? Yes, I can sell it to some person. So the person who's purchasing will have two options. So he can say, look, I don't want to take your property with loan. Whatever amount I'll pay you, you pay it off to the bank, get an NOC from the bank and give it to me, and then I will purchase the property with clear encumbrance without any sort of issues. The purchaser can also say, look, instead of you, I will step into the loan, okay, but you need to take permission from the bank. So the owner takes permission from the bank saying that, look, I am selling the property, and Mr. So and so person is going to come in my shoes and he's going to continue paying the EMI. So in that case, the person, whoever is purchasing, will come into the shoes of me, and then he's going to pay the EMI, continue to pay the EMI. So these are the options that, but nonetheless, when you're taking over a loan, you need bank approval. And whatever is the loan balance and the sale price, it needs to be settled between the buyer and the seller, whatever the difference amount is. And very, very important, the seller, that is the owner, has to pay all the property tax dues before registration. That is something that they are going to check, because otherwise the property tax, if there are any arrears, you will have to pay once you purchase the property. So this is something that you will have to know. And when it comes to NRI transactions in India, obviously, there are a lot of people who have purchased the property in India and are settling abroad, or are rather settled in abroad. Now, what if they want to sell the property? One, they have to come down to India and sell the property. Whenever the registration happens, they have to come down and be there. Or if they want, they can give a GPA to someone who's in India. But nonetheless, there are certain rules that they need to follow for GPA. The first rule being that GPA has to be, drafted and sent to them after the signature of the person who they are wanting to give the GPA to. Say, for example, my sister stays in America and then she wants to sell her property here. So she wants a GPA to be given to me who's staying in Bangalore. Now, the procedure is that I get the GPA done. I sign the GPA here. Okay. I send it to my sister in America. My sister signs the GPA there, okay? and then she takes it to the embassy, embassy there, and then Indian consulate and embassy there. She gets it signed and sealed in the embassy. Okay, saying that yes, the whole point of understanding why you need the signature from the embassy is because that she's staying there, and yes, she's a citizen of USA, or she's in part of, or she's rather staying in USA, is what they want to know through the seal and sign from the US consulate. So once you get the US seal and sign in consulate, and then you send it to us back to India, and we can get the franking done here in the sub registrar office, and that document is a valid document for me to register the property for my sister who stays in abroad in case she cannot come, right? Now, what is the law that is governing in India for NRIs? It is the FEMA of 1999 Act, and you have RBI, you have income tax rules and regulations that the NRIs have to see. And obviously, this whatever Karnataka state government has property laws, that will also apply to them. Now, very importantly, one major thing that realtors must know when it comes to NRI transaction is they can only sell residential and commercial property. If they cannot buy agricultural land, plantation, or farmhouse, they can't purchase it, okay, except it is inherited. So let's say my sister has, my father has a property and my sister is inherited agricultural land. That's a different story. But she cannot directly come and purchase an agricultural land or plantation, any plantation in any of the hill stations or farmhouses anywhere, because law is very clear. It clearly says they can only purchase residential and commercial property, and they can only sell commercial and residential property. Agricultural land, plantation, and farmhouses also, if they're selling, then they'll have to sell it to not an NRI, but to someone. Let's say I've inherited a property. I am in America. I've inherited my father's property, which is a agricultural land. Then if I have to sell that property, then I can't sell it to an NRI. I have to sell it to someone who's in India. So that is the law, right? So that is very clear on that aspect. Now, when it comes to accounts, these people need to have NRO accounts or NRE accounts. No cash transactions are accepted in India. Legally, I'm speaking, no cash transactions are accepted. Okay, and obviously, agricultural land, like I said, can only be sold to resident Indian. So only Indian residents can purchase an agricultural land from an NRI who has inherited the property. And also that there is a cap for how much you can purchase, or how much you can do transactions in India for an NRI. It is 1 million per financial year. So 1 million is what USD 1 million is what they are allowed to do per financial year from NRO account. And obviously, for us as residents of India or citizens of India, we have to pay TDS. Well, whenever there is a transaction sale happens, we pay TDS. So the TDS for us is 1%, whereas for NRI, for long-term gains, it is 20% TDS, and for short-term gains, it is 30% TDS. And rental income are taxable in India for NRI. So this is something that you will have to know. And coming to general power of attorney. So,
Lalita,
yeah.
just 1 second. Anyone has any questions so far? Please feel free to ask. We will take a couple of questions, if any. Whatever we discussed so far.
Hey, hi Lalita. I have a quick
Hi.
question.
Yeah.
I am Shobhit. So regarding the NRI transactions, whenever I go to some NRI, first problem is proving that nobody tells you that they are an NRI. How to find out that? Second is they don't agree to this 30% or 20%. They say they'll get some document from income tax department. I'm not very sure how valid is that and how to check its validity of the document. Please throw some light on that.
Yeah, sure. Usually this is something that usually keeps coming. So OCI card is what is very important. The moment they become a citizen of a different country, they will lose Indian passport. They will have something called as OCI card. And I am sure there are so many people Even with OCI card, they have Aadhaar card. So there have been situations where using Aadhaar card, they have done transactions. These transactions happen, but that is not actually right, because later, if the income tax department gets to know that they are actually OCI people who's having an Aadhaar card and doing the transaction using Aadhaar card, not OCI, then it becomes an issue, because the person who has purchased the property will have to pay heavy fines. So it is always important for us to check whether they are having a OCI card. If they have the OCI card, then you have to educate them saying, please don't use your Aadhaar card. If you're using the Aadhaar card, also use your OCI card, so that you get to know why they don't use their OCI card. It is very simple. They don't want to pay the 20% TDS. I'm sure it's a big chunk of money that is going to go to the tax. They don't want to pay such amount of tax. And when they say they're going to bring a document, I don't know what kind of document is going to be entertained with the tax department, because they're very, very strict on this. Because we ourselves have seen two of our, transactions long back, even after warning them, they have used the Aadhaar card instead of OCI, and the purchaser, even after warning, telling them multiple times, they have got the notices from the income tax department, from the tax department. So there is no shortcut way to it. Obviously, people use the shortcut way because they don't want to pay 20-30% of TDS. They want to evade that. But if you say OCI card is what proves whether you are a citizen of India or whether you're a citizen of some other country, because if you're not citizen of India, then you're going to get an OCI card.
Just a small add-on question. Just a small
Yeah.
question. Yeah, so I have come across some people, like what they have done is they have moved to US on a H-1B visa. They are Indian citizens, but they moved on a work visa. How to deal with that?
No, work visa still they're not considered. Only if they have got the citizenship, only then it is considered as the OCI. Not someone who is not under H-1B visa. They're still part of, they're still citizens of India. They still have, they still come for visa stamping here to India. So in that case, they're still citizens of India. Unless until their visas are getting stamped in India, they're still citizens of India. So they'll have Aadhaar. They can use their Aadhaar. The moment you are still citizen of India, you come under the ambit of 1% bracket of TDS, not 20% of the bracket.
Okay, sure. Thank you.
Yeah.
Anyone else? Okay, thanks, Lalita. We can move on, but just one correction. Recently, the TDS rate have changed actually. So from 20%, it has come down to 15%.
Yeah,
with all the bells and
recent
whistles for NRIs.
Yes.
And one more thing, what I heard recently, that if your legal status is NRI, right, then this law of TDS also applies to foreigner also. So you could be holding Indian passport but staying abroad for a long time. You are liable to pay the TDS as per the NRI also only basically.
Yes.
There are
This is
gray
absolutely
areas.
Yeah, gray areas, and also with the matter of fact, this absolutely comes under the whole tax thing comes under the ambit of chartered accountants, and
Yes,
it's a very tricky question, law when it comes to tax law. Yeah. Someone raised their hand.
So Sobit, what I can do, like we can discuss later on. I'll connect you with my chartered accountant. You can talk to that person.
Sure,
go ahead, Priyanka. Yeah.
Can I move on?
Go ahead. Priyanka had some question. Go ahead, Priyanka.
Priyanka, do you have question? Yeah.
Yes. I have a question that in our case, in case the client has like the property is in a father name, okay, and now the father is no more, and there is no will or something like after if father is no more, what is the next step? So if there are 2 or 3 kids, how would be the legal challenge if they want to sell?
So obviously, when a person dies intestate, this is where the situation arrives, because this has always been a situation where they don't write a will, and they die, and there'll be three kids. One of them would be staying in abroad, two of them in India. Now, what to do? In that case, what option is there is that they have to get an E-Khata done in all the three people's name, because they are equally the owners of the property. So they are going to be three people who are going to sign, or they can say, both of them can give an NOC saying that I want my brother, or a person who's staying in India, to be the a holder of the property. They can give a NOC saying that no, I want so and so person to become the owner of the property. Otherwise, legally, it is three people who needs to have the E-Khata in their name, and then they will have to do a after the E-Khata is done, then they have to produce the E-Khata to the sub-registrar, and they have to do a partition deed or something like that, where they divide the property amongst three people. And tomorrow, if they want to sell the property, then they'll have to sell their share of the property. So this is the usual thing that people do.
Thank you.
Thank you.
I think, thanks, Lalitha. I think we can move on.
Yeah, sure. So when you talk about GPA, so usually GPA does not give any sort of ownership that most of you are aware. It is just a part of, I am not able to do something, do it on behalf of me. So in that case, it does not transfer. There are so many people which we have come across where in the GPA, they sell the property. That's not a valid sale. GPA only gives you the power to sell. GPA in itself is not a sale deed. So that is something that one must know. Okay. And like I explained to you earlier, there is a process for NRI GPA. Getting it, Indian embassy, you'll have to get it, register it in India within 3 months. That is, getting it franked, from the sub-registrar within 3 months after the embassy has signed it. This is something that you will have to know when it comes to NRI GPA process. Now, very importantly, a new thing has come up. In the sub-registrar office recently. Now that they're asking a life certificate in GPA. So what is life certificate? They have a format that you will have to comply with. That format has to be sent to the person who has given the GPA. Let's say my sister gives a GPA to me to register her property in Bangalore. Okay. And I find a nice prospective purchaser. And I say to my sister, look, I found a prospective purchaser. He wants to purchase the property. So everything happens. Everything is sorted. Now, we go for the registration. When I give my GPA saying that, look, my sister is in America, she's unable to come down. So she's given the GPA to me, and there's a purchaser who wants to purchase the property. Okay, look at this. And if I give the GPA, now the sub-registrars can ask, now they're making it mandatory to ask a life certificate. So they'll have a format. They're going to give the format where we have to take the life certificate, this format, and send it to my sister in America. She has to fill in the details there, and she needs to get it signed from Indian embassy there, and then send it back to me to India, and I have to go present it before the sub registrar saying that the person who had given me the GPA to do the transaction is still alive. Why they are doing it? There are so many people apparently are selling the property when the actual person who was given the GPA is no more. So there have been multiple litigations that has come up with respect to this GPA issues, and that is why they have made life certificate a mandatory rule in Karnataka. So I think, yes, sir.
So question regarding this old GPA, has there any rule how old the GPA could be to have this life certificate, like 5 years, 10 years?
Any GPA as such is valid. If you take legally, it is valid for 6 months. So any GPA which is more than registered, it is valid for 1 year. If it is an unregistered GPA, it is for 6 months. So anything more than 1 year, they are going to ask for life certificate. Nonetheless, the sub-registrars have an option to ask even if it is 3 or 4 months old also, because it is made discretionary to sub-registrar. So it is up to their discretion. They can ask. There have been episodes after this law was passed, when we got a property registered, it was again a GPA property, but the sub-register did not ask for the life certificate. But it is going in rounds. There have been other people where the registration has happened, where they have specifically asked for life certificate. Even the one person has given it from medical practitioner. So they've gone to the doctor, they have got it certified that he's alive. He has signed it and sent it from Mysore to Bangalore. So this episodes, and this has happened because he was bedridden. So obviously when someone is bedridden and they give a GPA to a person who's staying in Bangalore and the property is located in Bangalore, they have to do the registration in Bangalore. He asked the doctor to come to his house and gave the GPA, gave the life certificate, sent the life certificate, got the property registered here. So there, it is absolutely discretionary made, even if it is, they say, actually, as per the law, 6 months is validity for unregistered and 1 year is for the registered document. But nonetheless, they have discretion to ask if they want to ask, because they have made mandatory now since about 1.5 months. This is going on round, sir.
In the previous slide, you mentioned that a GPA has to be registered within 3 months of signing.
Yeah.
Right? For the NRI. Yeah. So this 3 months, from which date you count actually? From the day the
embassy
document
signs it. Embassy.
But okay, embassy signs it. Okay, thank you.
Yes. And continuing, obviously, old GPAs without life certificate apparently should not be accepted by the sub-registrar. And obviously, what is the impact? There would be delays for you. There would be delays in registration. And why they are doing this is because to authenticity, reduce fraud, and make sure that is a valid authority is there. So these are the main, this is an important update that has come with respect to GPA, right? The one of the last topics is RERA and buyer protection. Obviously, most of you, or rather all of you here, are RERA certified realtors. So obviously RERA is very important because it is mandatory for the new and under construction projects. It protects the buyers from delays and fraud. It actually also protects the realtors as well, and ensures disclosure of approvals and timelines. That is why RERA is important. And what is the benefit of having RERA? What if RERA was never there? There are people who are still purchasing property without RERA. What happens to them? Nothing. There is no harm in not purchasing a property, or which doesn't have RERA. You can purchase a property which doesn't have RERA. Nonetheless, when you purchase a property with RERA, it is more transparent. It is timely delivered. So you make sure that the project is delivered timely, and you have RERA to always support the purchaser. It is more purchaser friendly. They make sure that the developer or the developer gets heavily fined if he's delaying the project. But when you see something risks of non-RERA project, no, law does not say please don't buy non-RERA project. Law nowhere says that. It says it comes with risks. What are the risks? Delays and incomplete project. What if there is a delay in project, incomplete project? You will have to go to consumer forum. Okay, because there is no RERA here, you have to go to consumer forum, and obviously no guaranteed refunds or compensation. You will have to keep waiting for it. That's the only issue if you buy non-RERA projects. Okay, so this is something. Say for example, buyer A, who was promised, who takes a non-RERA project, was promised 3 years. Within 3 years, I'm going to deliver the project, but obviously it is delayed indefinitely. It is still stuck in court. Okay. Now, let's say buyer B purchases a RERA property. There is a 6 months delay. Then the builder is ordered to pay interest until the possession. So this is what is the benefit of having a RERA project and purchasing a non-RERA project. So coming to some of the couple of success stories that we have done until now is there was a buyer or our client who wanted to purchase a 1.2 crore site, and we figured out that the papers were forged papers and there was litigation court case on it. So obviously the buyer didn't want it to go with court case. It is not advisable to go for court case whenever the property has court case. So we told absolutely no to it, and obviously it helped the client to save a lot of money. And the second thing is there was this project which the possession was delayed for almost 3 years. Okay, and we raised the complaint under RERA. And until now, I think recently the property was handed over. Until then, the property, the monthly interest was paid to the purchaser. So RERA is a bliss or a blessing in disguise. And whenever there is khata confusion, we clearly tell the purchasers the pros of having a khata A. We tell the pros of, the cons of having khata B. We make it very clear. As an advocate and as someone who is, guiding you through this, I would tell you very clearly. Please inform the clients very, very clearly of what khata A and khata B is, and also what are the pros and cons of both the things. So I think we also did the same thing, and we made sure that he takes a guided decision that what is right and what is wrong for him. And yes, there has been tenant issues that is going on. A lot of eviction matters have come up in recent times. After COVID, especially, there have been immense tenancy issues, eviction cases that has come up because either the tenants don't have money to pay, or the owners are selling the property to someone else. So one such issue happened where the buyer assumed property was vacant. He thought, okay, it is a vacant property, and then he purchased the property. Later he realized that there was tenant who was there in the property, and when they came to us, we amicably resolved it and said tenant to move out, and then you resolve the matter, but without going to the court. But there can be situations where it reaches to the court. So these are some of the things that we have done until now. So yeah, for any other further queries, you can reach out, and thank you so much for your patient listening.
Yeah, we have many questions
Yes.
actually.
Yeah, please.
Go ahead, Pawan.
Yeah, go on.
Thanks, Lalitha ji, for a brief insight on the property matters. So my question is related to particular clause which we see mostly in the sale deed drafts. So this is regarding indemnity. So is a seller legally required to provide indefinite indemnity to a buyer, or does the law impose a limit to it?
The law does not per se say there is indemnity is always there on the seller part. But these days, what I have noticed is in the sale deeds that comes for the review, what I have noticed is they're putting a specific clause saying that the indemnity is only for 3 years from the date of purchase and not beyond 3 years. Okay. Any litigation comes for 3 years, then they'll be responsible to handle it. Otherwise, they are not going to handle. Now, actually, technically speaking or legally speaking, that's not right, because law clearly says that 12 years, for especially for a situation like this, limitation says 12 years, where I can always come back and say that's my property. I have a share in the property and file a case against someone. So if it is government, then it is 30 years as per the Limitation Act. So we usually don't put the numbers, or rather in the previous sale deeds, if you see, they have never put the numbers saying that after this I will not be held responsible, only because there were situations where acquisitions can happen anytime, because if you never know whether it is a government land or whether the government, let's say Inam abolition and all, Inam back in those days, Inam would have been given and they would have taken the property, and later they would have given it, divided it and given it to multiple people, and there would have been issues, and suddenly out of nowhere someone says I have a right in the property. So it is usually advisable not to write the number of years where they say that I'm liable only for these many years. Post that, you won't be making me liable for any of the legal this thing. But There have been trends like this that is noticed. There are people who are registering it also. Sub-registrar are registering because sub-registrars read certain clauses which are mandatory that they read. Very surprisingly, with this clause saying that, for 3 years, beyond 3 years, I will not be responsible, the sub-registrars are accepting. In that case, now I say, you can write it, but it is again left to the sub-registrars whether they want to accept it. If I were to be a sub-registrar, I would not have accepted. But if it is someone else to be sub-registrars, with their knowledge, they might even accept that.
Lalita, question on that front. Suppose it's been 4th year now for me, and I was the buyer. Can I still go to the court because the court says 12 year, right? I can go and if some issue happens.
You can.
So does
you
that
can go.
Even if they put something 3 year, is that statement legally valid?
Statement is not legally valid, sir. Statement is not legally valid. Yes,
so just
because Limitation Act clearly says. Limitation Act is very clear on that. It says 12 years, 30 years. End of the story. The moment the buyer can always go file a case in the court.
Understood.
So that means, just to conclude, that means whether written or not, the law still prevails and the buyer can always dispute in case there is a claim by another party.
Absolutely.
Up to 12 years. Fair enough. Fair enough. Thank you. Thank you.
No problem.
I think Isha had a question.
Yes. Hi, Lalita. So,
Hi, Isha.
I was just curious to understand, these kind of transactions where property owners have lost all the originals, including the sale deed document, and, then they complete some paperwork like filing an FIR and public notice, etc. After which they try to just put the property on the market at a price significantly lower than the prevailing market rates.
Yeah.
All right.
Yeah,
so I've noticed sales have happened smoothly around me. So I was just willing to understand what are the repercussions of such transactions. Right.
The law is very clear on that. Law clearly says if you have lost the property papers, what is the first step? Give FIR. Then these people will have to look out for the property papers. If they can't look out for or rather if they don't find the property papers, they give you an acknowledgement saying that we are unable, search report will be given to you, which says that, we are unable to find the property papers. And next thing what happens, you do a paper publication in 2 newspapers, one in English, one in Kannada newspaper, saying that so-and-so property papers are missing. We are unable to find it and this is what has happened. And post that you apply for a certified copy. You take the certified copy, you do the sale deed like any other normal transaction, you finish the transaction. Law is very clear in it. It does not say you have to sell it for a depreciating value. What happens is people are, from the day one or from times immemorial, they have kept that certified copy. Obviously, certified copy is not original. Law is also clear on that. Certified copy is a copy of what is original, which was there with them. So it cannot be considered as an original copy. Nonetheless, it still has a value before the court of law. So certified copy still means something. Rather than giving a Xerox copy of something, certified copy has a way higher, greater value. So I would say that even with a certified copy, there is no requirement for you to sell a property at a very lesser price. Nowhere in law it says so.
All right.
Right.
Thanks, Lalita. Anyone has any other question?
Hi, I'm Krishnan here.
Yeah, hi.
Hi, I wanted to know one clarification.
Yeah.
Whenever we buy a property, we check, we go through the family details of the property.
Right.
So how many years it is valid? That is how many years I should see. That is, for example, if I'm buying today, generally we look for 15 years of property history. What is the...
usually 30 years, sir. We usually see for 30 years.
Okay.
Yeah. We usually see for 30 years. That's why encumbrance certificate, we usually ask from 1995.
Okay.
1st April 1995 till date. But usually they always prefer to give from 2004 because from 2004 only it is digitized.
Yes.
So it is easier to get, because otherwise they
Yeah.
have to go for handwritten one. It will take
Handwritten one.
more time. I'm sure
Yeah.
most of you have, realtors
Yes.
only have said, Madam, please ask from 2004. But
Yeah.
legally we tell from 1995.
Okay.
Good point. And
Thank you.
Dolly,
Thank
I
you.
think you have a question. Please ask. Dolly, you can go ahead.
One more question I have.
Yeah.
RERA is
You're
not
on
that
mute,
effective in
Ram.
Bangalore.
Yes. Okay.
How do we buy any property which is been registered with RERA? How do we believe or depend on RERA registered properties?
I didn't get you.
I'm talking about under construction or newly launched projects.
Right.
They register with RERA to comply with the government system.
Correct.
And what is the benefit I have as a buyer to depend on them when there is no validity or there is no teeth with RERA at all? They are not effective at all in any way.
RERA is effective. I mean,
In
unless
what way?
until.
In what way? One, when the builder defaults, they don't have any teeth to give any compensation to the buyer. One. Number two, when the builder.
Krishnan, I think this is the out of scope for this
Okay.
webinar.
Okay, then sorry. Thank you.
Validity of right. So I got your point. What you're trying to convey. Let's stick to the Q&A basically, which is on the legal ambit. And
Thank you.
Go ahead, Dolly. You had a question.
Thank you.
Yeah. Dolly, you're on mute. Dolly, you're on mute.
It can be a foolish question also, this, but I want to clarify this. There is for example, if there is a litigated property and the owner is staying abroad and it is rented out. And so what are the challenges a tenant faces? And most of the time when we have CEOs and other higher officials coming for rental agreements, they want to, clarify if the property is clear or not from any encumbrance. And that is the time the owner says, what, he is not going to buy the property, right? He's just going to stay in as a tenant. So, in spite of the encumbrance certificate, we find there are a few points where the property is not clear.
Yeah.
So, what are the precautions we as realtors have to take, and what are the possible, legal mishaps the tenant can fall into? Just enlighten us, please.
Yeah, sure. So, like you said, the owner is in America or somewhere else, and the property here, property here is a litigated property, and they want to give it for rent. And then you take someone there. And obviously, any person rather should ask, or rather you as realtors should ask EC and other basic stuff, even though it's a rental property.
Yes.
I always see this misconception in realtors or in the people generally at large, that they don't want to check. They say, oh, it's a rental property, that's fine, let me go in. No, it's not that.
No.
You need to check basic stuff. I'm not asking you to check 30 years of, how they have got the property. But basic stuff like, are they the present owners? First thing, the current sale deed. Secondly, has the property tax been paid? Because tomorrow, if BBMP is sending the notice, you will be receiving at the house the notices. And thirdly is the E-Khata in their name. Why E-Khata? Because there have been multiple episodes of demolitions in Bangalore because of issues that it was constructed on Rajakal Way or, multiple such things. So just to be on a safer end, you need to check at least these three documents along with EC to understand whether there are any sort of litigations or any issues, this is something that you will have to educate them and tell them that look, you will have to do this, and so that they build that trust with you guys. And when you say what is the remedy that can be given if they want to still go ahead, I would say litigating property, there are obviously issues that can come up when it comes to a litigation property, even if you're giving it for rent, because there might be situation, it might be resolved at that time, and a new owner might come to that particular property, and new owner might say, look, in other whatever 11 months you have to vacate this premises, then he has to vacate the premises. He has no other option, even if he has invested a lot of money in beautifying the apartment or beautifying the commercial space. He will have to leave all that behind and go. For that reason, you have to say whether it is a litigation property or not. That is very, very important.
One more question.
Yeah. No, I'll just complete one point. I'll just complete one point. Make sure in the rental agreement, you include saying that this is a litigation property. And if there is a new owner that is going to be, coming in place of the present owner, this particular, rental agreement will continue until so and so date. So this particular thing, so that in the tomorrow there is some issue or eviction happens, there is a clause that is mentioned which is going to safeguard your tenant, because he has invested a lot of money. And also when it comes to investing a lot of money in the rented premises, you will always, we see realtors don't write any of the items as to how much a person has invested. Tomorrow what happens, the tenant leaves and goes, so many items will be intact, and some items it will not be properly inspected, and they'll have issues between the owner and the tenant saying how much money I have to give for the damages. So always please make sure that you write, after mutual inspections, both of them are going to come into consensus as to how much is the damages that one has to pay. It is always made. I've seen so many rental agreements which says the owner will decide as to what is the amount that has to be paid for the damages. No, it has to be mutually done. Mutually, both of them should inspect and say what is the amount that will go for the damages.
One more live example I want to give, and I want to ask a question. This happened with me. Now, there was a set of lawyer startup from the US who was trying to take up a rental office space. And one property was identified by me in the CBD. It was a build to suit. It was a full floor. So on the face, they said they will be taking up half the space on build to suit, and some we had come down to a particular per square feet rate, and after which I was kept out of the loop. In spite of my follow-up, I was kept out of the loop, and they acquired the property within 3 months. So in this case, where do I stand? Now,
so
neither am I
getting very important
neither am I
questions.
getting my
Absolutely.
rental commission nor the thing.
Absolutely. No, this has been a major thing, especially when a realtor is affiliated to builders, especially. Okay. What happens is, I take a client as a realtor, I introduce it to the builder, and I am there all through the process. But one sudden day, the client calls me and says, I'm sorry, I don't want to purchase the property. I'm not interested, and cut the call. After 1 month, you are taking one more client, and you see that the previous client had already purchased a property directly from the builder.
Yes.
You have introduced, and this happens. This is a lot of times.
In this case, can you help out? Because there is already a mandate from me. And beware, these are very sharp lawyers, and they are in your international forums. So they are very, very sharp and shrewd.
Yeah, I'm sure. No, this has been happening. Most of the places, most of the realtors are facing the same issue.
Yeah.
So what I'm going to tell you is, see, this I have told to most of the realtors who have come to me. They say, Madam, this has happened. So I always ask them, why don't you just sign one small MOU or an agreement with both of 1-page agreement?
It's done. All that is done. all that is done is what I'm trying
then
to say.
you can always sue them. I mean, with the agreement, no doubt.
So
I mean, you don't put it on the
one,
stamp paper.
1 minute.
Yeah.
So Dolly, in the interest of time, I will share the contact details of Lalitha ma'am in the Kriya WhatsApp group also.
Yeah. Sure.
And in the chat also. I should just add them in them so others can ask questions. Otherwise, it will go on. Na?
Yeah.
But I have also gone through this scenario, and we have filed many legal cases in the court. So it's going on currently.
Yeah.
Go ahead. And before I ask Priyanka, anybody else have any questions?
Can I just take 2 minutes?
Okay, last 2 minutes. Go ahead, Dolly.
So now what happens is either when I'm suing them, I'll be spending more of my time and my money. And if I don't sue them, I don't get my money. And if I keep sending them emails, there is no response. That is the situation.
Yes, there are pros and cons for that.
Yeah.
Absolutely.
Yeah.
We can discuss that in person when we have a conversation.
Yeah. Please. Yeah. Thank you.
I think someone else is,
Priyanka.
the previous property owner collected security deposit from the tenant, but has now sold the property to you know who is legally responsible for refunding tenant. Oh, this is a common thing that happens. It is the previous owner who has to pay. Whoever has collected has to pay it. And how this should be documented in the rental agreement. So we have to specifically say if there's a new, that is why in the rental agreement, there should always be a clause which talks about what if new owner comes. This is something you all have to see to protect your client's interest. If there's a tenant or even if it's a buyer tomorrow, they should also not be blamed for any of these things. So please write a clause which says if a new buyer comes, then the new buyer the old owner will hand over the security deposit amount to the new buyer, and the new buyer will be responsible to give the security deposit to the tenant as and how they are quitting the premises. And if the old owner takes the amount, he will be responsible to pay it. So this clause will protect your interest. See, so many things what happens, unfortunately, they get the agreements done from someone who's sitting under a tree. They draft the agreement and then they bring it, or they take help of AI and do things and they bring it. But when you go to the court, it is not going to have it. At the end of the day, knowledge is knowledge, AI is AI. I mean, at the end of the day, legal knowledge is what is required to do things. So certain clauses and certain things have to be put in to make sure that the tenant's rights is protected. At the same time, the buyer's right is also protected.
So Lalitha, that's why we invited you, not AI chatbot.
No, the AI is the trend, sir. So that's why, I had to put it forth, because there are people who have come up with AI agreements and shown to us saying that, can you review this agreement? I said, AI can also give you prescription for a doctor. Would you take that? No, no one would want to take a prescription what AI gives. Then why for advocates?
Agree. Go ahead, Priyanka. You had a question?
Ma'am, I have a question that if I'm the buyer, I purchased a property around 3 crore, and we made an agreement between the seller of say suppose normal 500 e-stamp paper, and everything is ready from my end. I want to go ahead with the registration. Okay, so within say suppose in a 15 days we have planned for a registration. Now seller said, I don't want to sell you. One of the buyer is giving more money, or I purchased in a 2 crore, they may be offered 2.5 crores of the same property. So now the seller wants to back out.
No, that is not possible. That should not be done. Yeah, go on.
Yeah, as a buyer, if I'm going legally, so what if the seller says that I'll give the penalty and I'll go back, but that I don't want to do. So what kind of situation seller may face, I want to know.
See, I'll tell you one thing. Here, there is two things that you have to keep in mind. One is playing smart. The other one is, taking things very, into the ego and going into legal battle. That he can always do. Go to the legal battle, sue saying that, look, I wanted to purchase the property. I want to file a case. He's not ready to give me. He's given it to someone for 2.5 crores. Now that person is going to come to the court and say, yes, I have done the mistake. 2.5 crores I'm ready to sell. I am ready to give some good amount to him. He is not ready to take. Then what can I do? Okay, now the smart move would have been you take extra money penalty, not get into the mess. Okay, and move out. Because once you get into the mess, what happens? Legal battle fees, okay, running to the court, and then it takes own sweet time of 1 to 2 years to get everything resolved. I mean, if you are just satisfying your ego, then that's the right thing to do. But if you are want to act smart, then take the extra money that the fine that the person is giving, and then you can go back. But both options are open. Legally, yes, you can fight.
So Lalitha, question is, but legally now, suppose I go to the court, maybe satisfying my ego, whatever, right? Will I win the case? Does the owner can walk away? Can I just pay the penalty? Or just will take a call?
The court is going to be biased in this because we have had this episodes earlier wherein the court has clearly told, see, why are you so adamant in purchasing the property? It's not that it's the only one property that you're going to get in the same area. Okay. Correct. Unless until it is there are episodes where the court has also said you've been staying, so they have a reason. I've been staying in the same apartment. I want to purchase the apartment now. They've agreed for 60 lakh rupees. Now they've found someone to pay 80 lakh rupees. They want to go to them. There is a valid reason that I've been staying there. Then the court is going to be considerate on that. But if it's a new property, and then I am like so adamant saying that even if they're ready to pay the fine, because there's only compensation that even court can offer. It can't force someone to do it unless until there's a clause and other things. Even if there's clause, they can't forcefully push someone to sell it. Unless until the court finds the actual reason, yes, there is a reason. Like this, where I've been staying there for some 20, 30 years, and or let's say 10 years, and I want to purchase the property. I have set up everything. I've invested some money in the property for interiors and everything. Then court will be considerate on that instances.
Understood. Point taken. Himani, the last question. Then I think we are done for today.
Yeah, hi ma'am. I have one question for the rental agreement. Let's suppose the property is fully furnished. So tenant is staying, and as per the agreement, 1 month rent should be deducted at the time of move out. But tenant will not pay the rent of last few months, so just to compensate the deposit. So and it is a fully furnished, and he can move out without because he don't have any furniture and all. So what legal action we can take in that?
As such, security deposit amount is given for the security purpose. So that is the whole point. You can't per se go file a case against them in that case, because court is going to say that's the whole point of keeping a security deposit amount for 12 months. Usually for 12 months they take. Now people take for 6 months, 8 months, 10 months, how much ever they want. But usually 12 months is given so that in case they don't pay you that amount, you can deduct it from the security deposit amount. So for that per se, you can't go file a case. After the amount is totally gone and there is arrears or dues, then only you will be able to file a case before the court.
Yeah, because as per the agreement, 1 month should be deducted for the painting and the cleaning, all these things.
Correct. So that they have to deduct either from security deposit amount that they already have, or if the arrears, if the security deposit amount is totally gone and there is arrears, so if they really have to pay, then yes, you can go file a case. But for 10,000, 20,000 or 50,000, who would want to file a case is a question. But nonetheless, if they want to go ahead, absolutely under the law, they can go ahead and file a case.
Any questions from audience? I have one last question from my side. So what is the proper way to cancel a sale agreement?
Proper way to cancel a sale agreement. Okay, so
both the party agreed they want to buy.
Yeah, they can go ahead.
Token paid. After 1 month, they both decided mutually we want to back off. So mutual agreement.
Cancellation of sale agreement. They'll have to execute a cancellation of sale agreement. They'll have to go mutually and cancel out the sale agreement, and they're going to get some amount refund of what they have paid as stamp duty registration fee. Some amount will be refunded. Some amount will be cut and kept by the government. So that is, again, the treasury will decide on the amount and things, but they will get back some amount as a refund. So cancel, if both of them mutually agree, then absolutely it is through cancellation of sale agreement, they can cancel the transaction. Now, someone even asked me, just to give you an extra tip on, can we cancel the sale deed? There have been episodes where you can you cancel the sale deed after the registration has done? That you can do only after the court orders, nothing over and beyond that. If court orders, yes, cancellation of sale deed is okay, and then it directs the sub-registrar to cancel the sale deed, only then a sub-registrar can cancel a sale deed. But that's not the case with sale agreement.
In case of sale agreement, in cancellation of sale agreement, does it have to be again on the stamp paper or normal paper will do?
Stamp paper would be ideal.
And what would be the amount?
Stamp paper amount, again, so if you're getting it, so if it's a registered sale deed, sale agreement, then it has to be a registered cancellation agreement as well. If it is an unregistered, sale agreement for 500 rupees stamp paper that usually people take these days, then again, cancellation also they do it in the 500 rupees stamp paper. There is no hard and fast rule as to this much amount. They even do it. So sometimes sale agreement amount, stamp paper, they even do it for 2,000. I've seen people doing it for 5,000. Even though 0.5% we can do it as a stamp paper where it can be redeemed later. Even then, people would do it for 1,000, 2,000, 3,000. And for the cancellation also, they do the same amount.
Now, in case of sale agreement, there's a clause generally, right? Time is of essence. So within 90 days, they should both close the deals, right? Now, suppose as a buyer, I could not manage my fund in 90 days. Does that mean on 91st day, the deal becomes cancelled automatically?
Legally, yes. Because as per the law, time is the essence. When you write something and put it on a paper, so if I am signing any paper with someone, it is not a valid agreement. Only if it is some consideration or some value to the paper, only then it becomes an agreement. So if it's on a stamp paper, if I'm saying, 500 rupees stamp paper is there, I say 90 days, then yes, it is bound by 90 days. You can do an addendum to it where some people even write at the back, both of them sign saying another 30 days, both of them sign, finish off. Someone want to be more legally right, they do a addendum to it, addendum to the sale agreement, and then, add the clauses. They say the same will apply to this, and then sign it, and then you'll continue for the next whatever 30 days, 40 days.
Thank you so much, Lalitha. Over
Thank
to you,
so
Pooja,
much,
for the vote of thanks.
Yes, I usually begin that.
Tika, bolo. And we'll take a group
you,
photo
everyone.
also.
Sorry, sir.
Yeah, go ahead, Ayushi.
Yeah. Thank you, everyone, for joining us today. We hope this session gave you clarity on your legal and market-related real estate questions. A heartfelt thank you to Advocate Lalitha Sridhar for sharing her expertise and to Manoj Agarwal for facilitating this discussion. Before you leave, do look out for the feedback form you'll receive shortly. By filling it out, you'll get access to our guide on legal documents and common mistakes. If you'd like to stay updated on future webinars and insights from Agarwal Estates, we invite you to follow us on our social media channels. Thank you once again for being with us today. Have a wonderful day ahead. Thank you.
Let's take a group photo. Yeah. Smile. And Ayushi, did you mention about that tree plantation, or I missed that part?
No, I haven't mentioned that yet.
Yeah, go ahead.
Yeah, so basically we plant a tree for all our speakers. So we'll do the same for you as a part of our Plant the Planet initiative.
Thank you so
You'll
much.
get
That
the
means a lot.
certificate. You'll get the digital certificate on your email.
Thank you so much. Thanks a lot, Manoj sir, for this opportunity.
Yeah. Thank you, everyone. And we'll
Thank
share
you
our
all.
contact.
Thanks a lot.
Also, okay.